Good morning, everyone, and good afternoon to those of you on the East Coast. It's a great day here in New York. It's beginning of spring. Welcome to our third and our final program in our webinar series on Southwest Justice. We have a very full program today, lots of ground to cover. So I don't want to take up too long in our introductions, but I'm Steve Handelman. I'm director of the Center on Media, Crime, and Justice at John Jay College. And once again, I want to express a shout out to our partners and sponsors, the Academy for Justice at Sandra Day O'Connor College of Law at Arizona State University, and our partner, Erik Luna. So I'd like to welcome Erik onto the stage to say a few words, and then we'll move on to our program for the day.
Fantastic. Thank you, Stephen. First, I want to extend my thanks to Stephen, to Caddy Gray, to the entire team at the Center on Media, Crime, and Justice at the John Jay College of Criminal Justice. It has been a pleasure to work with you and collaborate on this very important event. I also want to thank my colleagues at the Academy for Justice, Valina Beatty, Ben McJunkin, Jennifer Jost, and Suzanne Stewart, and others for their work on bringing this event to fruition. As Stephen mentioned, very packed agenda for today. Today, we're going to take on the frontiers of criminal justice. They include issues of tribal justice, a poorly understood area of criminal justice in the United States, but one of great importance to Arizona and its sister states in the American Southwest. We'll also turn to a topic that pervades every aspect of criminal justice, and that is the question of mental health and its impacts on every aspect of the criminal justice system. And we'll finish up with a roundtable, including some of the nation's leading experts on criminal justice, who will help explore those aspects of crime and punishment that lie on the horizon of news coverage. Ultimately, we hope that our audience, particularly members of the media, will come away with a better understanding of the criminal justice system, or at least some key aspects of it, and more generally, a greater appreciation of the very human system that we have in our criminal justice process, the very human consequences for families, communities, and society at large, and the incredible need for accurate and fully informed coverage of this important area of our society. So without further ado, let me turn it back over to Stephen for the remainder of the day. Thank you, Stephen.
Thank you, Erik. I just want to add, you said it beautifully, that those of you of our fellows who have written stories or are writing stories, I just want to remind you, please send us the links. We can cross-post them on the Crime Report and certainly post them on the conference page. We do want to see what you're doing, and I think not only us, but your colleagues in the region and around the country. It's a great way of networking and really one good story always begets another one, which is our philosophy. So don't hesitate in sending me the links, either to me or to Caddy. So let's start with our tribal justice panel. We have three excellent speakers to take us through it. I don't think there's any more really interesting subject right now than the issues of tribal justice. They're largely uncovered in much of the country, although slowly they're coming to the fore. We have a new Secretary of the Interior, as you all know, who is a Native American, who many people feel will do a lot towards bringing the justice issues, as well as social justice issues, of course, for Native Americans into the fore. Our three panelists today are Alfred Lopez Urbina, who's the Attorney General for the Pascua Yaqui tribe, Addie Rolnick, who's the William S. Boyd School of Law professor at the University of Nevada at Las Vegas, and Lauren Van Schilfgaarde, who is the Manuel Band of Mission Indians Tribal Legal Development Clinic Director. That's a mouthful. So what I want to do is start maybe with Mr. Urbina, the Attorney General for the Pascua Yaqui tribe, and then go the other two with initial comments. We'll have a conversation and then throw it over to questions. So Mr. Urbina, the floor is yours.
Thank you for the invitation today. And I was invited to speak on this panel. I was thinking about what we were going to talk about. And I thought about I was thinking about that quote, if a tree falls in the forest and no one is around to hear it, does it make a sound? I thought about it. Justice fails on an Indian reservation and no one is around to see or hear it, does it make a sound? And so wanted to start the conversation just to advise people that there's an ongoing public safety crisis and a public health and behavioral health crisis in Indian country. It's also a crisis of morality when we talk about the effects of our institutions, the effects of our programs, and the lack of investment thus far, all resulting from hundreds of years of institutional neglect, programs and laws that weren't really meant to create thriving Indian communities. The structure was really meant to simply deal with the Indian problem of the time. And hundreds of years later, with the federal, state, and tribal government each having responsibility for some criminal and civil jurisdiction in Indian country, the problem has only grown and become more persistent. It's punctuated by poverty, disparity, a lack of housing, a lack of infrastructure, unemployment, substance abuse, and racism. Quite simply, lives are at stake. Here in Arizona, we look at the effects of the last administration, some of the justice programs, the intersection of immigration policy, the effects on Indian country in Arizona, the lack of federal, state, and tribal resources to address violence are issues that we've tried to address here locally on our reservation. We were the first tribe in the nation to prosecute a non-Indian for the crime of domestic violence. That happened on July 2nd, 2014. Since then, we prosecuted or investigated over 80 cases of non-Indian violence against tribal members. And we're able to address these interracial issues that occur on reservations to address violence, but ultimately with the new Biden administration and Indian country, it is my opinion that the carceral system is not, and the justice system as it's currently structured in a Western model, is not the ultimate answer to safety and justice in Indian country. I wanted to throw some questions out there for the reporters who are covering this. Essentially, what does it mean when we collectively think about safety on Indian reservations? Can we reimagine or co-create alternatives to bring back the peace that we knew before? What can a true coordinated Indian country justice response look like? What are the harms of our current criminal justice system, as flawed as it is, to our communities? If we are closer to the problem that we're experiencing, we're certainly closer to the solution. And if we imagine restructuring the system to address trauma through reconciliation, and we create community-based safety strategies and interventions to address the root cause of violence, would our communities heal? And can we invest in creative intervention strategies that are positive, life-affirming, with the transformative potential of undoing the harm that we've experienced in Indian country? Can our systems be built upon our cultures, families, compassion, and health? Through transformative justice, can we create community accountability? And can we more effectively, through community-based responses to violence and harm, through prevention, early intervention, education, and a rapid response to crisis, and a long-term process towards transformation, can we replace this Western model, that this Western carceral model that is certainly part of the equation, but ultimately will not be part of the answer that's going to make us healthy and safe and free from harm. And so I believe we can interrupt these criminalization pathways through holistic ways and things that are more consistent with our community values, our culture, and our families. Thank you.
Thank you, Mr. Urbina. These are excellent questions. Each one of those questions, I think, is worth a story. In fact, several stories. We at the Center on Media, Crime, and Justice had a tribal justice conference in Albuquerque about 6 or 7 years ago. And at that point, I don't know if any of you were there, but at that point, we established some of the key themes that you're talking about today. And it's clear that not a lot of them have been addressed since. So I want to go first to Addie Rolnick, and then to Lauren to discuss, if they will, some of the questions posed by Mr. Urbina. Then we'll get into a bit of a conversation about what we really lack. Because it seems to me that, we've been talking about some of the broken parts of our justice system in general over the whole series, and the experience in Indian country in all of them has been that much worse in terms of the suffering and the experiences of the flaws in our criminal justice system in general. So there's a lot to talk about here. Professor Rolnick?
Thank you. So my name is Addie Rolnick. I normally teach at the University of Nevada, Las Vegas in Nuuvi, Southern Paiute Territory. I'm coming to you from Coast Salish Territory, where I'm visiting at the University of Washington. So thank you for having me here. I've looked a bit at the agenda for the whole conference. My work is at the intersection of criminal justice reform and working with tribes and on Indian law issues. And so this is an area that I care a lot about. And I think our audience is mostly going to be non-native journalists interested from the criminal justice angle. And so in thinking about what to say at the beginning, what I want to do is emphasize 3 sort of overall themes that I think it's important to understand as context when asking questions about criminal justice in Indian country and as it affects Native people. So the first one is tribes are governments. That sounds really basic, but it's important to remember when covering Indian country criminal justice issues that tribes are governments navigating all of the same questions that the rest of this conference has covered. And they have to do that individually and at the government level in the same way that states do. Second, unlike other governments, tribes have to navigate within a very complex jurisdictional framework and a legal framework that makes them more vulnerable to challenge when they make basic decisions. So tribes are constantly on the defensive when making some of these basic governmental decisions. They're much more vulnerable to changes in the federal government's decision-making about money and priorities, and they're much more vulnerable to, when they make mistakes, as all governments do, to the possibility of having some of their basic criminal justice related powers shut down. And I'll explain what I mean by that. And then the third point, right, so tribes are governments, tribes are super vulnerable governments. And then the third point is over half of Native people live outside of Indian country. So when you're thinking about Native American people and criminal justice issues, particularly in the Southwest, there are going to be a lot of people who are Native people, because of where they live and where their offenses occur, are going to be under state justice systems. So they won't be in tribal systems necessarily, and they won't be under federal jurisdiction. They'll just be part of the regular state system. And in that context, Native people are greatly impacted by all the inequalities that I'm sure you've heard about for the rest of this conference that are baked into and are trying to be addressed in state justice systems. So on the first point that tribes are governments, each tribe has its own justice system. There are commonalities among some tribal systems, but there is no one model for what a tribal justice system looks like. And each tribe has to balance questions like, what does it mean to keep the community safe? How do we hold people who violate community safety accountable? How do we do that within significant financial constraints? How do we make sure we have the staff to cover all of the institutions that a justice system requires? How do we meet the needs of particular subpopulations? How do we allocate justice system resources? So questions like, how much do we put in? Do we need a detention center? How much money needs to go into the detention center? Does that mean that we won't have money left over to allocate for mental health resources? What is the thing people here need the most in terms of healing, and how do we balance, say, traditional concepts of justice with Western concepts? How do we make sure our decisions are recognized by other governments, but also true to what it is that that community believes? So those kinds of questions are constantly being navigated by tribes, and they're differently situated. But for some of the smaller tribes, so in Southern Nevada, many of the tribes are relatively small, you often will have a pretty small, so a smallish council and not that many heads of departments who are the people who have to navigate those questions. Sometimes they have expertise that they bring, sometimes they don't. But unlike in a state government where someone at the decision-making level might have a full department staffed with people and expertise in each area, many tribes don't have that. So they're having to make those decisions sort of constantly. And it's important to understand that context. As Alfred said, the other piece of this is that tribes are doing this in a context in which what we call the risk factors or the drivers for criminal justice system involvement are often much worse. So on scores like poverty, educational attainment, mental health, alcohol and drug use, those are all, you can write a story, and many people have, about how those indicators are worse, right? Unemployment is worse on many reservations. So this is an area in which just using what we know about criminal justice system risk and involvement, we might expect these are communities that often have high risk factors. So they're navigating it in that context, but also with limited resources, right? So the decision about whether to invest in, say, mental health services or punitive services, punitive interventions, often it's a one or the other decision because there's limited money. But the other piece of it that I think it's important to see is that tribes have been leaders in rethinking what justice might mean. So the rest of the country is currently caught up in trying to figure out how to replace this terrible, overly carceral, overly punitive, police-focused and prison-focused system that we've built across America. Tribes are struggling with that too, but partly because they've had to do it because of some of the limitations that they face, and partly because they've carried forward some of their traditional ideas of justice. They have already been wrestling with some of these questions about what makes a better justice system for a long time. And I want to suggest that for those of you outside Indian country, it's worth it to listen to what tribes are saying in this context and what they have done in terms of changing or keeping old approaches to the justice system, because something like restorative justice that you will hear thrown around outside of Indian country as a solution to a carceral system, the idea of restorative justice is generally based on ideas that came from various indigenous groups that were sort of imported into the Western context. So this is something where tribes have been a leader, partly because they've had to be, and partly because it is in keeping with the way that they see justice systems. It's worth it to look at the way that they've led in this area. So on the second point, that tribes are particularly vulnerable governments, there are two reasons for this. So one is what you might have heard of as the jurisdictional maze. In Indian country, tribes are the primary sovereigns, and they have to make decisions, and they should be the primary policy leaders about what to do, but they do it in a context in which there is almost always one other jurisdiction that they're dealing with. There will almost always be federal and or state jurisdiction also involved. And because of the way that that many tribal justice systems are funded, they are much more reliant on federal grants and federal formula funding, and the decisions that the federal government makes can sort of make or break the ability of a tribe to make its justice system decisions. Other aspects of federal government decision-making can have a big impact. So just to give you an example, if a tribe decides, as the Navajo Nation did, and as almost every tribe in the country has, that they don't want the death penalty to be part of their system, that is a decision that a sovereign ought to be able to make. But because the US attorneys have jurisdiction and can make some decisions about how to prosecute particular crimes, we recently had the first Native American executed on federal death row. And that happened against the wishes of the Navajo Nation, because tribes can't just make those decisions on their own. The federal government makes decisions about prosecution priorities through the Department of Justice that tribes aren't always able to control directly. So they're much more at the mercy in terms of setting those priorities of what the federal government is doing and the decisions that the executive branch is making at the level of funding and at the level of priorities for enforcement. The other piece of this, though, is not just financial and not just executive, but it has to do mostly with the judicial branch, which is that tribes operate in a legal framework in which many core aspects of tribal sovereign power have kind of not been tested in the courts. This is particularly true when it comes to criminal justice. So there is a basic understanding of what tribal governments have jurisdiction over and what they do not have jurisdiction over, but a lot of corollary questions like exactly how long can the police pick people up and hold them for a while? Can people be extradited? What happens then? Are state officers allowed to come in and serve search warrants? Do they have to talk to the tribe first? Those are questions that really haven't been through the federal courts to a great extent. So everyone is not sure what those powers look like and what it means for tribes. They're the only sovereigns where if anyone raises a question about how it is that they're executing a power, there's a good chance that it will go to court and that power will be taken away. So they are the only sovereigns on the whole that don't have basic territorial jurisdiction over everybody who commits a crime in their territory. And every time there's a question about how it is that a tribe is executing its policing power or its prosecutorial power, they're doing that knowing that if they don't do it exactly correctly, which many jurisdictions don't, part of being a sovereign is that you make mistakes in how you do things sometimes. Any mistake for one tribe is often going to be leveraged and responded to as if it's something that all tribes did. And then the possibility of that power being taken away from all tribes is a very real possibility. So that's a way in which tribes are constantly making these decisions in a way where they're much more vulnerable than other governments. And then the third piece, right, is about state jurisdiction, right? It's not about Indian country jurisdiction at all. So many Native people are living or committing offenses in places that bring them under the jurisdiction of state justice systems. Sometimes this happens in Indian country because of laws that give states jurisdiction there, but mostly it's happening when Native people are just living outside of Indian country. Then they just are in state justice systems just like everybody else is. And on this point, what I want to say here is Native people must be part of the national conversation about criminal justice reform. There is terrible data, but the data that we have suggests that Native people face as bad or worse disparities than other groups at almost every decision point in the justice system. So not so much on arrest, but on police violence, on the decision to detain, on the decision to incarcerate. On all of those decision points, what we see is that Native people fare worse. They get more punitive outcomes. We can see that in the data that we have, and yet we have these national conversations about criminal justice reform, and it's generally about African Americans. Sometimes someone will mention Latinx people, and then sometimes they'll say other people. But because Native people are often a small statistical piece, or because people don't understand how to talk about Native people, they just don't, which is a giant mistake. So Native people have a huge stake in these questions about what it is that state justice systems will do in terms of reforming their police, reforming their approach to incarceration, and they need to be part of that conversation. So there's a lot more to say on all of these. I wanted to kind of give you a basic framework, which is to say tribes are sovereigns. They are dealing with all of these questions every day. Second, they are very vulnerable sovereigns who have to do all of these questions at the mercy of federal funding decisions, federal overstepping, state overstepping often, and a legal framework that leaves them vulnerable to challenge. And then third, there are a lot of Native people who are in the state justice system outside of Indian country, and they need to be part of that national conversation as well.
Thank you, Professor Rolnick. Lauren, over to you.
Yeah, thank you. Hello, it's so great to see you, Attorney General Urbina, Professor Rolnick. Thank you for having me. Lauren Van Schilfgaarde, Coach de Pueblo. I'm the clinic director for the Tribal Clinic at UCLA School of Law, calling from Tovangnar, also known as Los Angeles. There's so much to say, and I want to compliment what both Attorney General Urbina and Professor Rolnick said. So I think first, just to sort of reiterate and highlight all of the many crazy things that were said, right? Tribes are both sovereign and ancient. And I think that this is understood, but it's also glossed over frequently, that the jurisdiction that tribes are exercising is distinct from the jurisdiction that the United States is authorizing. And we have to talk about, tribes weren't invited to the Constitutional Convention. And that's relevant because the source of tribal power does not derive from the United States. It derives inherently from tribal people. And it's that power that survives colonization, survives the United States, and is continuing to be operated today. That's relevant for criminal justice today because things like due process, equal protection, search and seizure, constitutional protections are not restrictions that apply to tribal governments. They are accountable to their own people. And so it's an entirely different legal analysis when we talk about what tribes can and should be doing. That informs, even though tribes are not constitutionally limited, they are obviously under the thumb of the United States in very meaningful ways. The United States, which is otherwise a country of limited powers, at least the federal government, has unlimited powers when it concerns Indian affairs, and they exert that in lots of different ways. That was for tribal criminal justice systems, which, at least from the point of contact up until the 1960s, was exercising full territorial criminal jurisdiction over all persons. That was drastically impacted in 1968 when the United States implemented the Indian Civil Rights Act, which statutorily imposed due process protections, though distinct, onto tribes. But for our purposes, they also put a sentencing limitation, initially only 6 months, that tribes could ever incarcerate any person. That has since been expanded to 1 to 3 years, depending on different considerations. But in its most robust form, tribal capacity to respond to crime is limited as far as incarceration sentencing goes. Then in 1978, under legal arguments that really boil down to colonization is a thing that's still happening, and because of it, tribes are lesser than other foreign nations, therefore don't have powers to prosecute non-Indians. And that's crazy as far as a legal argument goes. It also is a direct contributor to the public safety crisis that we see in Indian country. Ironically, the voices that really made known that there is a major public safety crisis within Indian country came from the international community. It was Amnesty International that came in with their report in 2005 showing there is a violence crisis in Indian country that is disproportionately impacting women and girls. Sound the alarms. Of course, this has been a crisis that has been centuries long and centuries in the making, but it's notable because it really got kicked into high gear when tribal capacity to respond was restricted under these really dubious arguments about how, quote, American tribes are, which also conceives of the criminal justice system on this linear framework. Incarceration is the only tool in the toolbox, and due process protections are the only metric by which we can measure whether a government is legitimate. In both of those instances, to Professor Rolnick's point, tribes were treated as this monolith, All tribes do have bad justice systems, generally. There has never been a systematic examination of whether a particular tribe has a robust justice system. Instead, when these are litigated, tribes are all lumped together, even though the distinctness of their sovereignty is isolated from each other, and the diversity in language and culture, in governmental capacity and governmental infrastructure is all over the map. So I just wanted to highlight that tribes are distinct. Tribes are distinct, and yet they are treated with this blanket, very old school settler colonial framework that is continuing to frame a lot of these issues. I mentioned this international report. I think there's lots of really interesting things happening on the international frame that is starting to challenge the way that we conceive of tribal sovereignty. Notably, the United Nations Declaration on the Rights of Indigenous People really highlights for Indigenous people all over the world, including those within the United States, have a right to self-determination. Self-determination is language that has been incorporated as part of the modern federal Indian policy, though we know both anecdotally and explicitly that a certain administration's understanding of tribal self-determination varies extensively, which begs the question, what should we expect of a Biden administration? It's really encouraging, while also of course, that we finally have this national recognition of a missing and murdered Indigenous persons crisis. That's a good thing. It's weird because it's not a new crisis, but it certainly is a crisis for many of the things that were highlighted here. I noticed, and I will get to some of the questions, right, but why are we just coming to terms that this is a crisis? In part because there has been this systemic erasure of natives generally, both of tribes and of individual Indians, but also because we have a really hard time identifying Indigenous people. And this is because Indigenous people is a complex identity that includes both as a racial category and also as a citizenship category, right? Indigenous people are citizens of their tribal nations, making them dual citizens of both the United States and their tribal nation. That includes rights to vote in both elections. It's also a racial category. And for a large number of Indigenous people, myself included, we are multiracial. We also are likely to be intermixed with lots of different people, making us really difficult to profile on site who we are. And so when we are in the course of a arrest or being processed in a jail, we're frequently not asked what our racial identity is, much less what our tribal affiliation is, and instead are guessed by someone else filling out a form on our behalf. And so Native rarely ever makes it onto that form, which not only misracializes us on that form, it also fails to capture our tribal affiliation and citizenship and any attendant notice that our tribe should get about our systemization gets lost in there. I wanted to highlight just a couple of other things that are impacted with the Biden administration that we potentially can anticipate. Secretary Haaland just created a new initiative within the Department of Interior about approaching the missing and murdered Indigenous crisis. This is a big fat deal, in part because Indigenous people operate criminal justice systems that impacts both the Department of Justice as well as the Department of Interior. And before, we really didn't have any meaningful response from the Department of Interior. So this is great. Even though the Department of Interior operates the Bureau of Indian Affairs, which includes an entire law enforcement arm, we finally have some movement there. We also saw a memorandum from President Biden early in his administration reiterating the need for federal agencies to engage in consultation with tribes. This was a reaffirmation of an executive order we saw from President Clinton. This is huge. Consultation is the manifestation of the nation-to-nation interchange, communication that should be taking place between the federal government and tribes, because tribes are not one glob, they are distinct sovereign nations. Of course, we've seen since President Clinton's executive order the actual practicality of consultation, especially between different agencies, is spotty at best. Some agencies are pretty good. Some agencies haven't even bothered to create a consultation policy. And the UN declaration really highlights that for a lot of countries, as well as the United States and federal agencies, consultation is treated like a notice, a public comment, a checkbox meeting. And that's not what it's supposed to be. It's supposed to be closer to something like free, prior, and informed consent that, as a matter of comity to another sovereign nation, is owed. which is evidenced only in part by the fact that many tribes have treaties that are international documents, merely representing that type of sovereign to sovereign relationship we're supposed to have. And this is only tangentially related, but it is certainly newsworthy and happened yesterday. Was it yesterday, the day before? The Brackeen decision came down in regards to the Indian Child Welfare Act. A real garbage decision from what I can see. It's 325 pages long with no real immediately identifiable holding. But nevertheless, we all are compelled to wade through it, not only because the criminal justice system notoriously intersects with the child welfare system in really disturbing ways, not only because even 40 years later, we're still waiting for meaningful compliance of ICWA, but also because the holding implicates the whole framework of the relationship between the federal government and sovereign tribes. It questions whether or not that framework should stay intact and whether tribal sovereignty should be continued to be recognized as a sovereign nation-to-nation relationship. And so the fact that we have judges that clearly are poorly informed about tribal sovereignty, much less about like the importance of the Indian Child Welfare Act and the fact that this is actually a more robust policy that we should be spreading to other groups, not taking away from Indigenous children, is deeply troubling. And it worries me that we should be anticipating more of these convoluted, disjointed, poorly reasoned decisions in the future. So that was a little bit all over the place, but I'm excited to dive into some of the questions.
Well, thank you, Lauren. We have a bunch of questions coming in, but let me start off the conversation with maybe Mr. Urbina. You identified two areas that I found interesting in terms of challenges to public safety in Indian country. One was what you call the crisis of morality, and the other institutional neglect, which I take it also involves a lack of funding, which is always been a clear problem. I wonder if you could take us through both of them more concretely, if you can. And Lauren mentioned the initiative on missing Indigenous women, which perhaps you can talk about as well, since you've been deeply involved in working on that issue as well.
Sure. I'll start with the missing and murdered Indigenous women. I was on the Arizona State Task Force, and we did complete a report last year that was submitted to the Arizona legislative body. Thankfully, the Arizona legislators that are working right now, they have introduced a number of bills that are tied to recommendations from that report that are moving their way through the Arizona legislature to adopt some of the recommendations we made to address this problem from a state perspective. To see that is encouraging. I think it's historic. It hasn't really happened. Although these issues are being addressed across the country in different states, these specific reforms in the form of Arizona law, if they get passed and signed by the governor, will be like additional first steps in trying to address the overall problem. And they include, what I consider low-hanging fruit. Some of them are easy, like simply adding a tribal voice on an Arizona State Justice Commission or board. Those are things that seem, they seem like something that should have happened a long time ago, and they're just now being introduced. The hope is that many of these bills will pass. They've received bipartisan support, which is highly unusual now, both at the federal and state level because of what's going on politically. But these bills are moving. They've been introduced by both Republican and Democratic legislators in Arizona to attempt to address these problems. So one of the primary bills that's being sponsored by Representative Jennifer Germain She's a representative, a tribal member representative out of the Phoenix Mesa area. She is actually moving a bill that will basically extend the Arizona Missing and Murdered Indigenous Women Task Force for another 2 years, fund it, and have us continue to do work, research with Arizona municipal agencies, police agencies, tribal entities, and also federal entities to try to address this problem going forward. So it's very positive. It's something that I have high hopes for in terms of the passage of bills that will address a number of different things. The passage through committees in Arizona has been, like I said, bipartisan, and it's been unanimous in terms of the votes that they receive. So I think we're developing a model that will allow tribes, the federal government, and states to work together, collaborate on justice issues, both at the state, county, and tribal and federal level. So I'm highly optimistic. I think a lot of these changes can be adopted and can be integrated with federal efforts as well. When we're talking about institutional issues, I go back historically. Some of the institutions that were set up to, not to create these thriving tribal communities, but meant to move tribes away from their traditional areas onto reservations without the structure and the infrastructure they need to keep them safe, to help them thrive, to give them the water and the resources they need to be successful communities. And so despite those things, the infrastructure still needs to be developed. It still needs investment. I'm hopeful that will happen here in the next few years under this new administration, under the leadership of Deb Holland and the tribal leaders at NCAI, different tribal organizations that will help put forth some measures to bolster either the current infrastructure, but also new programs that will help us help tribes develop their systems independently to address their individual community needs, away from a top-down model that is simply not working at this point. The crisis of morality is something that we talk about because it's something that's when we're not addressing these problems, when we're not focusing or even talking about these issues, it leads to additional violence, additional problems in Indian country. The cases that we looked at when we did the task force, the MMIWG task force report in Arizona, we talked to families, we talked to women and children who have been impacted by this infrastructure, and we made direct correlations to the system and the causation of these missing cases, these murdered cases. These stories aren't being told. You're not seeing these stories on Dateline, or you're not seeing local news coverage about a missing Native person. There aren't huge organized efforts to find missing Native persons, like you might see news coverage, national news coverage that covers missing children historically. You just don't see that. Each of you can kind of think about in your own minds and recall. I can't recall a story that has focused on a missing person, a missing Native person, a complete day-to-day coverage, wall-to-wall coverage. It's just not happening, even though those cases are documented. There's hundreds of cases that we've documented. The news is simply not covering those cases for whatever reason. To me, it's tied to morality. It's tied to information. It's tied to the information we receive And so if we're not hearing about it, it doesn't exist. So those are the connections I try to make when I talk about these issues. And I try to form the connections for people who are asking questions and who are interested in featuring these families and attempting to help solve the problem of violence or missing and murdered Indigenous women, or even asking about the structure of a tribal government justice system.
Thank you, Mr. Urbina. I wanted to just quickly go to both Addie and Lauren to follow up on the question of institutional neglect. And yes, you're right. We haven't, the journalists have not covered missing Native American women to the same extent they've covered other issues, although that's beginning to change. There's a major story in Alaska, which won the Pulitzer this year on issues of domestic abuse and missing women, which has changed some of the formula in terms of how journalists are covering it. But an issue that's really not really well understood by journalists, or for that part, most of Americans, is this whole question of the institutional differences and the conflicts between federal jurisdiction, state jurisdiction, and tribal jurisdiction. And that's both Addie and Lauren talked about that. And I'm just wondering, can we expect now with a new administration, a new Secretary of the Interior, who's much more committed to Native issues, for things to change? Will we get more money coming down the pipe for Native jurisdictional issues? I noticed the Cherokee Nation, Oklahoma, which has just received, was formally recognized as jurisdiction, and they're asking for money from the feds to help them extend their jurisdiction and actually do the job that they are now assigned to do. Considering how much money is being tossed out in terms of infrastructure spending and everything else, can we really expect a change in federal policy, and even in a bipartisan environment, which we don't necessarily have right now, to change the formulas and the climate of relations between the federal government and Native Americans? So either one of you want to chime in, then we'll go to questions. Maybe Addie, you first.
Yeah, I'll say a couple of brief things. So there's two parts, I think, to your question that are sort of different. So on the general question, so one thing you said is, I do think, at least the journalists that I've talked to, and maybe they seek me out because they're doing a careful job, so it's a biased sample, but I've seen some differences in how justice issues in Indian country have been covered more attention by journalists. Sometimes journalists I've seen doing a better job of understanding some of the legal issues than legal scholars do, who are not Indian law scholars. So I've noticed that change. What I want to say here is a big picture. It's a big picture chastising, which is to say, sure, jurisdiction is complicated, and there are questions, and we can answer. There's a basic confusing layer of jurisdiction, and I can sum it up for you quickly if you're someone who sort of isn't familiar with it, which is to say, in Indian country, on a reservation, the legal term of art is Indian country, but think of Indian reservations. The tribes are the primary sovereigns when it comes to criminal jurisdiction. They do not, for the reasons Lauren talked about, have general criminal jurisdiction over non-Indians, but over tribal members and other Indians, they're sort of the primary sovereign with criminal jurisdiction. So they're dealing with that in terms of their jurisdiction. Generally, in most Indian country, I don't even want to say most, so places that are not affected by special laws that give the states jurisdiction, the secondary sovereign would be the federal government. So the federal government is going to have the power to prosecute a set of crimes that fall under federal laws that are territory-based federal criminal laws. So generally that is major crimes, and there's a particular list of those between Indian people or by Indian people, and then so what they call interracial crimes, so Indian versus non-Indian or vice versa. People who are, when it's just non-Indian on non-Indian, that generally goes to state court. And then in actually about half of Native people in the country are under a jurisdictional regime where the state is the secondary sovereign instead. There's a lot of complexities under all of that, but the basic idea is that you have the tribe, and then they are dealing with at least one, if not sometimes two, secondary governments. That's why we call it a jurisdictional maze. it's possible to understand it. There's plenty of writing that kind of distills it down. So in this area, so I'm a non-native person. I work in Indian country. It's not that hard to understand if you put some effort into it. And there are a lot of other areas of law, say, for example, immigration, that are very confusing. But when it becomes a national issue, we do the work to understand it. It would never be okay to not talk about immigration problems or the border crisis because we say, I don't really understand immigration law. It's our job as anyone who is involved in these issues to understand the context. So the point here is some of the kind of neglect, what people point to is this, it's very hard to understand it, so we're just going to stay out of it. That's not an excuse. So it is hard, but it's the job of journalists who cover this, it's the job of policymakers to understand it in the same way that we have to understand it for any other population. That's the big picture answer. The second part of your question is any of this stuff going to change under a new administration? So yes and no, right? The jurisdictional rules are probably not going to change enormously. It is my hope, for example, that the newest push for the expansion of the Tribal Law and Order Act and the kind of jurisdiction that is granted under VAWA is to kind of expand tribal jurisdiction over non-Indians to another set of cases, not just involving direct domestic violence. So that could pass, that would change the jurisdictional structure, but that is going to take Congress to pass it. Other than that, most of the rules are going to stay the same. The big picture won't change much. What does change is, as Lauren was talking about, the tribes really, it matters a lot to them what the Department of Justice does and what the Interior does, what Bureau of Indian Affairs does in terms of budgetary decisions, and also what Congress does. So most tribal justice systems are funded by some combination of formula fundings. They're operating as federal contractors and they're getting money from the BIA as federal contractors to fund, say, their courts and their detention programs. So that's the first piece. Then maybe the tribe has extra money that they're putting in, maybe they don't, it depends on what they have. And then they're getting discretionary grants from the Department of Justice. And there, each administration just kind of changes its mind about what its grants are going to be and how they're going to be, and each Congress that passes a new reauthorization. And so those change, right? So for a while, tribes could only get grants to build detention facilities. They would go to Washington and say, we need a new court building. And the answer from the agencies and from Congress was, our grants only allow you to build jails. So if you want a jail, you can build one. If not, we don't have a grant for that right now. So that's a decision that is made at the level of Congress and at the level of the agencies. The other question is block grant funding versus targeted grant funding. So maybe people are excited about wellness courts and reentry, and there's a bunch of grants for those. And then in 5 years, there's no more reentry grants, no more wellness court grants, and then the programs dry up. What tribes have been pushing for years is a kind of a block grant structure that allows, and there's movement toward this, but it can be better, that allows tribes to just say, this is what we want for our justice system, and we're going to decide how to allocate it, right? We're going to move it. If we want to close our detention center and allocate it somewhere else, we're going to do that. We don't want to have to go back through and get a whole new grant and change the way it's reported in order to do that. So those two things, actually, the administration can have a great deal of effect on that. And so I'm hopeful that some of that will change.
And what's the response to that so far? Has it been lukewarm, warm?
You know, under the Biden administration, I'm waiting. I mean, I don't know. I checked the Department of Justice website to see if it's made any actual decisions or actual statements.
Yeah, we'll actually see once Biden releases their presidential budget. That will be the indicator of how they are, right? It's just recommendations to Congress, but how they propose to structure that. But otherwise, as Professor Rolnick said, they have been very paternalistic in how they structure those grants, and it's very, crumbs. And the only thing I would add to what Professor Rolnick said, which is a totally great, just snapshot of what's going on, is part of the reason tribes are overly dependent on this federal money is because they have a very limited capacity to tax on their own territories. And so there, other than tribally owned businesses, there is not the typical governmental structure to raise revenue like states enjoy, or even counties and municipalities. And so there's no reliable funding stream that would allow tribes to self-determine how they want to structure their own governments. And then second, it's even more paternalistic and restrictive for tribes located in PL 280 jurisdictions, or jurisdictions in which the state has criminal and civil authority over the tribes, that the federal government has interpreted to really relinquish even their minimal obligations to provide funding through things like the Department of Interior. And then it's even more restrictive and complicated for tribes located within Alaska.
There's one question I want to get to in our, sorry, Mr. Urbina, did you want to comment?
No, I'm just, I'm answering a question, sorry.
Right. So we have there's one question. Some of the questions in our box have been answered, but it's a question from Nikki Roberts. It's an interesting one, and I think you're typing an answer already, but maybe you could tell the group. Nikki Roberts wants to know, what does Black, Indigenous, people of color, a BIPOC solidarity look like in your respective areas, and how can bridges across differences be strengthened within this group? So that's a question for Mr. Urbina first, but I think all of you can answer it if you'd like.
Sure. There are connections that are happening locally here in the Tucson, Pima County, Arizona area. We are working collaboratively with Pima County and with a number of different community groups in what's called the Pima County Safety and Justice Challenge. It's from a MacArthur grant, and they're in several different cities across the country, but we're looking at disparity in local jails, in law enforcement. We're asking critical questions of each other. It's had a great impact the past year, but we're working across all races, all cultures. It's a very inclusive process that the county itself is basically looking at their structures. We recently had a meeting with this collaborative with our tribal council where we were able to ask questions pertaining to justice and race. Simple questions like, what does your law enforcement department look like? What is a breakdown of your law enforcement department? Do you even know how it's in terms of the population and racial makeup of your law enforcement officers, your prosecutors, your detention personnel? What does that look like? We're trying to address a disparity in a system, but we also want to look at our own institutions and how they're structured before we even start to look at how the systems are impacting, local tribes, local communities, the Hispanic community, the Black African American community. Those conversations are happening on a monthly basis. It's really creating a synergy that I think will lead to positive change within the system. It's already reduced the levels of incarceration within Pima County Jail after we looked at disparate impact to those communities and broke it out by race, and then asked questions of all the different stakeholders, including tribes. So it's just one example of how we're starting to make those connections.
Okay, thank you, Mr. Urbina. If I could ask the panelists, rather than answer each question individually, if you could hold off so everybody in the session can hear them, because I think they're all excellent questions for the entire group. So, Lauren, you were just answering a question from Felicia Fonseca. I wonder if you could just repeat it out loud and give your answer to it.
Yeah, sorry, was that the major crimes one?
Yes.
So generally, we do see this disparity in sentencing, certainly, but even how the crimes are prosecuted in federal and state courts. And so this is a situation of an Indian person committing a crime. If that crime had taken place within the city of Phoenix, right, we would see a state criminal response system that might include different plea bargains, the option for probation, and critically, the option for parole. We'd also see integrated community type programmings, maybe education, different programs like anger management, or other types of certifications, right? The federal system, as a general matter, was not designed to provide these types of community responses. That's for local governments. The federal system is designed to handle these much bigger issues, right? Except when it comes to Indian country. So a crime that takes place in Indian country, no parole, minimal, much more intensive probation, and very few of these community-oriented type programmings and continuing education, which means that because you're Indian and were prosecuted under the federal system under this Major Crimes Act, which is purely a jurisdictional hook because it's Indian country, you're going to be treated differently than you would if you were non-Indian or if you had committed the crime in a state jurisdiction. And so we have these totally disparate outcomes, even though it's because the federal government is exercising this concurrent jurisdiction. In theory, the tribe can also prosecute, but it's interesting even why we have these like dual jurisdictions taking place, right? The origin of the Major Crimes Act is from the 19th century under this idea that tribes, right, were incapable of responding effectively because they wouldn't use the death penalty. And so this whole idea that like tribes aren't carceral enough in their response, move over tribe, we need to take over, is antiquated. And the more we're learning about the criminal justice system now, we know it's just wrong. But instead, you know, Indian people now suffer under a far more harsh set of penalties than they would. And that's assuming, right, that the state system has like something glowing to say about it, which we could debate about, but at least it's not the federal system.
So Professor Rolnick mentioned in her response the issue of domestic violence and how, particularly on in the ways we can enforce offenses against non-natives who are involved in domestic violence. And that's an issue that hasn't been talked about a lot, although it's an issue as important and as serious as the whole question of missing Native women. And it's been complicated, like everything else, in Indian country by the pandemic. And I wonder if perhaps each of you can talk about how the pandemic itself has made issues of public safety and criminal justice even more difficult and more complicated on in Indian country, and what you're doing to address that. Perhaps Mr. Urbina, if you can start, and then we'll go to each of the other panelists in turn.
Sure. I was serving recently as a judge during the pandemic, and certainly through Arizona and throughout Indian country, we've seen we've been hard hit by the pandemic, with our death rates rising probably, I want to say, you know, at least 4 to 5 times the normal death rate during the year due to the pandemic. We here on our reservation, we have a tribal court judge who has been on a ventilator since December. So although we modified our work schedules, we stayed open as a you know, necessary service through the pandemic, and we developed programs and protocols. Did the testing, we rolled out the vaccine. It's been difficult, certainly working with the federal government, with IHS specifically, but we've got a pretty good handle on it at this point. But it did create a strain, a certain strain. It put a strain on our cultural ceremonies as well. We've lost a lot of elders, a lot of our knowledge. A lot of our families have been impacted. I think it's a little early still to know what the true impact will be going forward. We're still in a modified mode of operating, even though the vaccine rollout is I think about 30% with both tribal employees and also community members. So we're still doing that. The tribal businesses, the casinos were impacted. That impacted revenues that go directly to our court systems. Our programs, our education programs have all been impacted. Certainly the Recovery Act funding has helped, but it has it also has illuminated a lot of different possibilities and opportunities. We are now more flexible and agile because, hey, we're doing things like Zoom. We're doing meetings on Microsoft Teams. So we're flexible. We're serving the community in a different way, finding ways to do it in a safe manner, so that we can, get a, and it kind of shows the intersection of public health and safety and justice, and how that is also a justice issue, that it might not have been contextualized in that framework prior, but it is a justice issue when you know that your healthcare system is such that impacted by a pandemic more than the other populations. And I talk to people and tell them, well, it's not the tribe's first pandemic. We've had pandemics historically since 1533, from Europeans coming to tribes, and so it's wiped out whole populations, whole tribal groups. So this is a new pandemic for us. It's impacted us in terms of deaths and changing our family structures, but it also highlights how resilient we are and how these justice concepts are tightly woven with our public health system, and so to me, I think we're gonna come out stronger. We're gonna come out better. I'm excited for the future, and I lost a brother during this pandemic. I had to go through a funeral during a pandemic, so I understand what our families are going through, and so it's still happening. We're still trying to recover, and we're going to be. I think we're going to be okay on the back end, but it's been illuminating for sure. And our justice system has evolved in that it's impacted the people who were incarcerated because we made changes to how we were doing things. We were doing public health checks, temperature checks. We were postponing a lot of what was happening in the justice system for the purposes of public health. So we know now, I think, that those things come before, and they can help us address our social public health issues that we were looking to our justice system to try to help address.
Thank you, Mr. Urbina. We have about 5 minutes left, and I wanted to bring up a question that Tim Igo was just asked, and put it to all of you as kind of to make your final points. And it's really based on something that both Lauren and Professor Rolnick talked about in terms of how the tribes have handled the issues of justice and healing and restorative justice. And Professor and Lauren Van Schilfgaarde mentioned the issue of capital punishment. And Tim Igo asked specifically whether, now that a growing number of states have begun to ban capital punishment or reassessing it, should that cause lawmakers to reassess the supposed softness of Indian country institutions and carceral issues? And I would add to that the question of what we can learn in our own broken justice system in the rest of America from how Native people have used and applied justice for the last few centuries. I mean, is there now a point, an inflection point, where some of the things that tribes have been doing can be borrowed or used in the majority justice system? So I want each of you to answer that, perhaps in turn, but maybe start with Lauren, then go to Professor Rolnick, and then Mr. Urbina.
Thank you. I think this actually is what Attorney General Urbina has been talking about like this whole time, right? Of like reimagining it. And so, yes, I think states are finally beginning to ask the right questions towards catching up with tribes, which really questions a lot of the foundational assumptions for how we build a criminal justice system, right? What's the goal? And this whole Western framework structures it's adversarial, and it's the defendant versus, quote, the government. The people, but it's the government, right? The victim has no standing in this process whatsoever. And because punishment is our only hammer, right? Every problem is a nail. And it really it supposes that the best response to crime is to remove criminals. And so I think an Indigenous perspective, which is a totally pan-Indian generalization, which we shouldn't be doing, but to generalize, right, is that Indigenous communities are too small to have throwaway people. We can't afford it. And so it also sort of ignores the issue, right? Crime is generally considered a symptom of some other ill in the community that requires restoration, reharmony, rebalance, which means we need to understand why this crime took place. And so for a lot of Indigenous systems, the approach is to bring together those impacted, which includes the offender, it includes the victim, but it frequently impacts the entire community. We need to understand how we all are impacted and how we're going to make this right. Sometimes that means that the offender does in fact need to be removed from the community. But more often than not, it means that the community frequently has obligations to each other, including to the offender, to right whatever motivated the wrong in the first place. And I think those are the shifts that we all need to take on when we think about how do we actually make for a more responsive community justice system, and in like economic Western metrics that we frequently come down to, that'll be cheaper and that are more likely to reduce recidivism, right? The goal is to reduce crime. It turns out that incarceration is an incredibly expensive way to make more crime. It's not effective. And so if we're going to entertain how to be more effective, we need to start to question those foundational assumptions that build the system in the first place.
Thank you. Let me go to Professor Rolnick for another minute, if you can, and I'll go to Mr. Urbina before we have to close.
Yeah, so I'll just say one brief thing, and there's another question in the chat I wanted to answer real quickly. So I agree with a lot of what has been said, which is to say, so tribes are not, I don't want to suggest that tribes are doing a perfect job of executing different sorts of justice systems and kind of doing something totally alternative. First of all, it's a terrible irony that many people have pointed out, which is 100 years ago, the justice systems that tribes had to address crime, the way that they were understanding crime as a rupture in the community that is necessary, in order to heal it, that sort of rift has to be healed between the offender and the victim and the entire community. It's an interesting way to think about criminal justice that's very different from the sort of individual rights versus state framework in Western system. That whole thing was sort of undercut, and it was the basis for supplanting a lot of traditional systems. And then tribes, in order to have their systems respected by other governments, kind of had to, in many ways, and also because of funding, follow the model of Western systems. So as a consequence, a lot of tribal systems look very much like non-tribal systems now. At the same time, these are communities that have had, their entire exploration of modern criminal justice systems has been defined by trying to balance what are usually called kind of traditional approaches with Western approaches. And so they have a lot of experience in trying to think about how those might go together. Often we see, so I work in the context of juvenile justice, and we've been talking about this issue a lot, which is to say that we think of something like a wellness court or a peacemaking court as an alternative or a diversion program. So they're often structured as, we still have arrest and prison all the way through, and then other things might just be kind of side programs. Well, what if we reimagined it to think of the other thing as the primary system? Like, what if the main way that you dealt with an offender was through a non-punitive system and you didn't have it as an add-on to a punitive system? It's harder to imagine that, but there are examples in the context of tribal governments building. There's a lot of examples in child welfare and juvenile justice because there's not as many restrictions in terms of having to look like Western systems there. So you see a lot of real innovation at the level of what tribes are doing, but it's often invisible because we only know to look for the things that we understand to be courts or prisons. So one example in child welfare that's easy to point to is adoption. You have a lot of tribes who have some version of what they call traditional adoption, and all that it means is that you don't have to terminate. You don't only get 2 parents. You can have more parents, right? It's really weird to think of if you haven't grown up in a community that recognizes this. Why is it that our legal system says you can only have 2 parents and you have to terminate the first parent to get another parent? You could have a whole different model, but you have to look at what tribes are doing in order to even entertain that vision. So in terms of revisioning, there's a lot that that tribal systems sort of can teach, and I think that they're also struggling with that question. The other thing I wanted to come back to real quick that was answered, but I wanted to say it again, I think it's important, is one of the early questions about data. So the data on Native people is very sparse, and what are some of the problems? There's a lot of problems, but some of them are very basic, and particularly for people working in state systems. There isn't even an agreement as to the definition of a Native person. If you're thinking about people who might be affected by tribal jurisdiction and by Indian country rules, then your definition has to go with the federal definitions of Indian and tribal member. But usually when states are collecting data, they just kind of look at a person, as Lauren said, and kind of guess what they are. So you don't have, at a very basic level, you don't even have states filling in a thing saying, is this person a tribal member and what tribe? There's no blank on their form. And for whatever reason, they're very resistant to adding that blank. At a very basic level, states could collect this data. The other piece of it is that if you look at a national level, Native people are 1%, but at a local level, like in particular states, they're a much higher percentage. Right. And sometimes you need to look locally in order to be able to figure out where the disparities are.
Okay, thank you. Let me stop you there and give the last word to Mr. Urbina. Mr. Urbina, another minute, if you can.
Sure. We here locally are developing a program. It's called the Tawahi Initiative. It was an Obama-era program that was rolled out in 2015. It's a family-centered program that is centered on the interconnectedness of living things. Tawahi is a Lakota word that means family, and basically it is a reimagination of taking federal dollars and basically modifying your system to do what works for your specific tribe. It's a pilot program. It's ending, and we'll be putting out a report to Congress here shortly. But it essentially is taking a different model, a different approach to address these problems that we've been talking about. It's a family and service coordination between programs within tribal communities that connects critical services, but with families as the core. And so and it's based on a New Zealand Maori model that we've adopted through the Bureau of Indian Affairs to basically serve our community in a different way, in a different, something that's really gonna help look at the health of the community and the underlying problems. We don't use Tawahi as the word. We call our program Itam Yoemia, which means family in our language. And so that's what we're doing to try to address things. It's a brand new program, but it is based on a program that was started in 2015 through the White House Generation Indigenous Initiative and out of the White House under, I think, the First Lady.
If you have a link to that, could you send that to us? Because we can post it.
I will.
Yes.
I will.
Okay, I'm going to have to cut you all off there, unfortunately, because we're just about out of time. But I want to thank all three of you for a really absorbing discussion. There's no way we could have covered all the ground that's really important to cover. And at the end of our session today, we're going to be looking at some of the key stories to watch, and certainly tribal justice and the evolving nature of tribal justice as we enter a new administration, and a new Secretary of the Interior is one of those stories. So if any of you can come back in the afternoon, unless you're certainly welcome to stay with us for the rest of the day, we certainly welcome you to look at other stories and how journalists can cover this issue. We do have Native and non-Native journalists in our fellowship this week. So you'll be talking to both people who know what they're talking about and writing about, and those who don't. So, but anyway, thank you all very much for your participation. It's been great. We'll take a 15-minute break, and we'll come back for our next panel on navigating reentry. Thank you all.
Thank you.
Yeah.